The September 11th, 2019 meeting of the Municipal Code Enforcement Board is called to order. I'm the chair, Richard Schmidt. Please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Ladies and gentlemen, the Municipal Code Enforcement Board is charged with conducting hearings to determine whether an alleged violation of the city code has occurred. Decisions made by the quasi-judicial board will be based on the evidence and facts presented tonight. Our meetings are conducted in accordance with Robert's Rules of Order, and each case will begin with the city presenting its evidence of the alleged violation. The respondent will then present his or her case. Both parties will have an opportunity to cross-examine all witnesses. The board members may question any witness. Comments by both parties must be relevant to the case. Persons wishing to speak tonight will be given the opportunity to do so by the chair and must address to the board from the podium after giving their name and address. Upon request, copies of materials submitted by staff are available for review. Board members are reminded to obtain permission to speak from the chair, and questions of the city should be directed to the attorney for the city. At this time, I will ask all persons who expect to give testimony tonight to stand and be sworn in by the city clerk. Anyone planning to give testimony tonight?
Please raise your right hand if you plan to speak tonight. Do you swear or affirm that the testimony or evidence you're about to give or present is the truth, the whole truth, and nothing but the truth?
I do. Thank you. Cases will be taken out of order tonight to accommodate respondents and witnesses present at tonight's meeting. For you guys up here, the first case is going to be case 19-3378. The second case is going to be 19-4158. And the third case is one lien reduction, and the fourth case is going to be the second lien reduction. Okay. The first is going to be the approval of the minutes. Has everyone received the minutes for August 14th? Yes. And had a chance to review any changes made that need to be made here tonight? If not, call for a motion.
So moved.
Second.
All in favor? Aye. Opposed, nay? No nay. It was Napke and Snelling. Was it David?
David
I'm
made
sorry,
the motion.
David.
David made the motion, I second.
Thank you, David.
My pleasure.
Ex parte communications.
Good evening, board members. At this time, I'd like to ask if you've had any ex parte communications regarding any of the matters that will be coming before you this evening. If you've had verbal communications, if you could please disclose the sum and substance of those communications, with whom those communications occurred, when they occurred, and where they occurred. And if you've received any written communications, if you'd please disclose the nature of those communications, from whom they came, and then provide a record to the city clerk so it can be placed in the record.
I've had none.
Knocking and
None?
None.
none. None.
Thank you. First case, please.
Case number 19-3378, City versus Alex Del Monte for the property located at 212 Park Ridge Avenue. The case is before the board based on alleged violation of Section 1034 sanitation, keep premises clean. The case will be prosecuted this evening by Officer Doug Allen. The city has evidence that the notice of violation and the notice of hearing were properly served.
Good evening, Mr. Chairman and board members. Doug Allen, Code Compliance Officer. This case originated proactively by me on June 14th, 2019. My inspection on that date revealed a cluttered carport. I left a door hanger with a reinspection date of June 21st, 2019. My reinspection on June 21st showed no change, so a notice of violation was prepared on June 21st with a compliance date of July 1st. I posted the notice on the site, and a notice was also posted at City Hall, and copies were mailed, both certified and regular mail, to the address of the owner of record. The resident did contact me and requested an extension until August 6, which I granted. The resident contacted me again, asking for a reinspection as he felt the site was in compliance. Upon reinspection, I contacted the resident and let him know that I did not feel the site was in compliance. A notice of hearing was prepared on August 27th, and the case was scheduled for the September Municipal Code Board meeting. At this time, I'd like to submit photographic evidence of the site taken by me on June 21st, 2019.
Without objection, the evidence will be admitted into the record.
Exhibit number 1 shows the posting of the notice of violation, and exhibit number 2 shows the cluttered carport. This time I'm requesting a ruling.
Is your, was I not paying attention? I know I was shuffling paper, but did you say it was in compliance?
No, sir.
It wasn't in compliance?
It's not.
Is the respondent here to speak?
I don't know.
Okay.
So
I'm sorry.
the picture that we saw of the carport, that's your most recent inspection?
Yes, sir.
And was there any difference, or what would you describe as the difference between the first inspection and the second, when he thought he was in compliance? What did he?
There's some difference, yeah. I mean, it's not quite as cluttered as it was in the beginning. Percentage-wise, it'd be kind of hard to say.
Okay.
I don't know, 25, 30% better.
Mr. Lloyd?
When was your reinspection date?
The original reinspection date was June 21st. Then the reinspection date after the NOV was July 1st,
And then you gave them an extension till,
August 6th,
and then when did you inspect it after that?
August 27th.
Okay. Thank you.
Sure.
I-
Mr. Knapp?
Do we have pictures of August 27th?
That was a picture that we have is
That was the
representative.
picture we
Yes,
saw.
sir. Yeah,
Okay,
that's
I'm
representative of the 27th.
Dated-
It's dated, but there hasn't been any change since
Okay,
then.
okay.
Any other questions? Thank you. Name and address, please.
Alex Del Monte, 212 Park Ridge Avenue. So just in regards to the picture alone, you can see a table saw, you can see shelves, you can see things that I'm doing to show improvement for this specific case. I contacted Doug. He gave me some advice on to get shelves, so I have those things to try and improve my situation. I'm a reseller. That's what I do for a living. So when I started, I made some mistakes and I accumulated some clutter. So the table saw is for interior shelving, and the metal shelves are obviously for exterior. And it took me a while to accumulate them. But as far as a reinspection, I never discussed an extension, but I did request a reinspection. And it just, for what I've done to the property, I've gotten it tented for termites. I've gotten a giant dead tree removed. Those are expensive things. And a cluttered carport. It just, for what I've done for the property and what I'm being charged with, it doesn't seem very fair. And I don't seem to have a voice in what I can and can't keep on my own property.
Well, there is a code that's applicable to all citizens,
Yeah, and I understand
And-
that.
and you allegedly have violated that, exceeded that expectation. As we're here to hear this tonight, do you feel that you can bring it into compliance in a reasonable amount of time? Or is this the best it's going to get, I guess?
No, I mean, sure, I could make it spotless if that's what you want, but if I'm keeping, I have wood that I'd like to keep out of the rain. I have boxes for my packaging, all my shipments that I keep there and I think they're pretty, it's hidden, they're there, but I have to keep it protected from the rain, and that's the only spot I really have. So,
What I would suggest is that you get with the inspector and further reason out what his expectations are going to be. You're not, I assume then you're repairing the house to sell?
no.
You're repairing it to live, you intend to live there?
Yes.
Okay.
Yeah, absolutely. Yeah. So, and the only problem I have is that the fines, for lack of a better word, threatened on me $250 a day for exceeding that, for this kind of a gray area and no clear communication as to what needs to be done. And as I've shown improvements, it just feels a little bit heavy.
Have you been a resident of Temple Terrace prior to this, or are you new to us?
I'm new. I've been here a year.
Well, welcome.
Thank you.
It gets better. Okay.
No, go ahead.
No, I don't have anything. I was,
Mr. Nopke.
How long do you think before you're going to be finished with whatever you're doing inside? Obviously, it's not outside, but if it's inside, whatever.
Yeah, interior wise, it just depends on what, I would rather know what I need to accomplish before, because theoretically I could do it in 24 hours. I mean, but it's honestly, it's a little bit of stubbornness on my part, because I feel like everything's pretty well contained. It's my things. That's kind of where I'm at.
Okay. What, as we hear on it and vote on it, and what will automatically happen if you're, whichever way the vote goes, okay,
Okay.
is that you would have 30 days to correct the situation
Okay.
and before a fine would start. So your being here tonight doesn't mean that a fine of $250 starts tonight. Okay, I just want you to understand that to relieve some of your anxiety.
Okay.
But you have 30 days to prevent it.
Could we clearly discuss, what needs to happen and how it needs to
You
be
talk,
maintained?
we don't do
Yeah.
that. You talk with your,
Okay. With Doug.
with Doug.
I do have a question.
Mr. Lloyd.
So you mentioned there's a little bit of stubbornness. Is that correct?
A little bit, yeah.
Okay. So if we give you some time to do it, do you think you can work with the code compliance officer to get it
Yes.
to where it needs to be? Yeah, okay. Thanks.
Thank you. Any other questions? There being none, thank you. Call for a motion.
I'll make a motion.
Mr. Lloyd.
Okay. In case number 19-3378, I move that the city has proven by greater weight of the evidence the following violations of the City of Temple Terrace City Code exists on the property located at 212 Park Ridge Avenue. The motion is based on sworn testimony this board has received from the code enforcement officer and Mr. Del Monte, along with any other evidence, including photos, affidavits, and the notice of violation, all of which is received and entered as part of the record of this hearing. I further move that said violations be corrected on or before
Night.
October 9th. Wow, that thing's almost... If the respondent doesn't comply with this order on or before that day, they are ordered to pay a fine for each and every day the violation continues past the date set for compliance. Upon considering the following factors, the gravity of the violation, any actions taken by the violator to correct the violation, and any previous violations committed by the violator, I move that the fine be $30 per day. And, well, that's it.
Mr. Chair, if I can,
Yes.
before we try and look for a second, I don't believe Mr. Lloyd noted what code
I
violations
did
were
not.
violated.
Thank you.
So, read the whole thing over again, probably?
No,
Okay, I'm gonna go back.
Code violation,
Yep.
moving to be in violation.
An addendum there, and it's for the code section in question is 10-34, sanitation to keep premises clean.
I'll second.
Second by Mr. Snelling. Any discussion? There being none?
Well, I was gonna say, I was gonna go 2 weeks, but since we'll give them the 30 days.
30 days is fine, I think.
Yeah, I think we'll give
30
them,
days is fine.
we'll give them enough there.
Yeah, and, you know, the pictures don't look like it's insurmountable.
Right.
So I think 30 days, he and code should be able to figure
Right.
something out. And if, God forbid, something should happen, and you come back in 30, if it's not cleaned up in 30 days, make sure you're back here so you can explain why you might need some more time. Okay? And welcome to Temple Terrace.
Again.
All right.
Okay, motion and second. All in favor?
Aye.
Aye.
Opposed? No nays. Thank you. Next case.
Just stay in touch with code. They'll work out.
The next case will be repeat case number 194158. Repeat case number 194158, City versus Rebecca Mariana for the property located at 406 Dunedin Avenue. The case is before the board based on alleged violation of Section 12860 inoperative vehicles, outdoor storage equipment. The case will be prosecuted this evening by Officer Jose Silva. The city has evidence that the notice of violation and the notice of hearing were properly served.
Good evening, board members. Jose Silva, Code Compliance Officer. This is a repeat notice of violation that was presented to the board on December 12, 2018, MCEB 18-3665 for an inoperative vehicle. At that time, the board found a violation did occur and the respondent given time to correct the problem. The property was brought into compliance on January 16, 2019, and no fine accrued. On July 15, 2019, I received a citizen complaint about the inoperative vehicle in the driveway, along with other code violations at the residence. Responded to the scene, at which time I observed the inoperative vehicle in the driveway of the residence. I noted overgrown yard conditions, vines on walls, peeling paint, and trash, loose trash in the yard. At this time, I left door hangers at the residence with a compliance date of July 20, 2019. An inspection on July 25th, 2019 revealed no change, so I completed a notice of repeat violation for the inoperative vehicle and notice of violations for the other violations that were at the residence. No one was home, so I posted the notice at the home as well as City Hall, also mailed copies of certified and regular mail to the address of the registered owner. This time I would like to submit 3 pieces of evidence. First one's going to be the notice posted at the front door. Second one's going to be the copy, a picture of the inoperative vehicle in the driveway. And the third is going to be the finding from the Municipal Code Board in December 2018.
Without objection, the evidence will be admitted into the record.
Thank you.
Given the 10 days for service for the repeat violation, the property was out of compliance for 3 days from August 5th through the 7th.
August 5th?
August 5th through the 7th.
Okay.
August 4th was a 10-day that we needed to have for service,
Oh, okay.
so, which was a Sunday. So Monday, Tuesday, Wednesday, and it came into compliance on August 8th, which I have an affidavit of compliance for that.
Okay, but I'm a little confused. I thought you were out there the end of January and it was not in compliance.
July.
July, okay.
July.
Sorry. Thought you said January.
Without objection, the evidence will be admitted into the record.
Thank you.
And the other violations that were for the notice of violation have been corrected at the house.
Okay. Are you going to submit,
That one,
they were corrected?
they were
prior-
corrected prior to
Okay,
this.
so this is just the repeat,
This is just for the repeat, sir.
okay. Is the respondent, well, are there any questions?
Yeah, I do. For him.
Ms. Rosa?
Yeah.
Go ahead, sir.
Were you the inspector in January 2019 when the inoperative vehicle was there?
Yes, sir.
Okay. Is this, to your recollection, is this the same vehicle?
Same vehicle, sir.
Okay.
It was, he was given the opportunity to cover it. It was covered. The cover blew off and broke up,
Okay.
and they were using that limb to cover the tag up.
Okay.
Any other,
No, good.
Question.
Mr. Mopke?
What did you observe was wrong with the vehicle? Is there like flat tires or?
There's no tag. If you look at the photo, there's no tag on the
That's
vehicle.
just the issue.
That's the issue.
Okay.
Every vehicle in City of Temple Terrace has to be registered.
Okay. Or at least covered up so you can't see it.
Trying to cover it up. You
Yeah.
can still see it from the street.
Well, I mean, but if you put a car cover over
If
it,
you put a car cover, you're fine.
okay, that was my question. Thank you.
Any other questions? The respondent is here. Thank you. Mr. Sewell?
Hello, Joshua Cottrell, 406 Dunedin. I'm not on the name, I rent, but I'm showing up for the owner, so. Yes, but, yeah, I fell behind on keeping up with stuff, and the car cover broke during one of the summer storms, you know how we have. So I was out of compliance, I can't deny that, and just here to, it was the end of the semester too, so final exams, but, you know how that goes. But other than that, yeah, I was just letting you know that's why.
Are you working on getting the license for it, or doing something with the vehicle, or covering
I
it?
do plan on it, it's just, you know, other stuff comes up.
What do you mean, plan? Is it a long-range plan?
It's not short range, I'll say that. I put a car cover on it, and I do want to get it registered. It's
Well, the
just-
car cover that's the progress that
Yeah,
and
yeah,
that's-
it's covered now, I mean, but.
that's where I was going. I was,
yeah.
you know,
Yeah, it's covered. Bought a new one, and shouldn't be any more big summer storms. Fingers crossed.
yeah, hurricane.
Yeah.
Okay, any other questions?
I do. So it's currently covered, not as we saw it in the photo? Is that
Yes,
correct?
it currently is.
Not at the most recent inspection, however.
Right. But as of today, it's covered.
As of this meeting, it might be covered, right?
Covered on the 8th.
On the 8th,
Eighth,
yes.
that's what I say.
A little over a month.
Mr. Chair,
Yes.
the violation is against what I guess is the property owner, which is Ms. Mariana, Rebecca Mariana. What we have here is the tenant. Remember, the order ends up as being a lien against the property. So do you have authorization, any type of written evidence of authorization to speak on her behalf?
No, I don't.
I would then treat this case as an absent respondent, giving this gentleman, obviously, he's had all the time in the world to talk, but remember, this is not a violation against this gentleman, it's a violation against Ms. Mariana. So I would treat this as an absent respondent, make sure we got, verify the notice, and then move forward like that.
Okay, we do have the verification, well, it has been noticed. properly noticed. We heard that earlier.
I just want to verify that the property owner received notice. Because again, this is a lien, would end up being a lien on that property.
Okay. Kristen, do you have any notification of that, any verification that we can do? It's- we're talking 3 days.
I did work with the property manager to get some of this stuff fixed, like the painting. So the property manager knows. I would hope that she'd let the owner know, but
Well, that probably would be, yes, that, but we don't know
yeah,
for
you have to
positive.
verify.
We did send it to the mailing address on file, which is not this property. It's a different mailing address, and we have not received any green cards back, but it didn't, I don't believe it came back.
Okay.
Just, Kristen, just to verify, it did get mailed to Rebecca Mariana?
Yes, it did.
Thank you.
We haven't gotten proof positive back, correct?
But the property was
Was
also
noticed.
simultaneously posted, so
Okay.
in my opinion, the notice is notice to the property owner.
Okay, do you have any other comment?
No,
Okay, thank you. There being no other questions,
I do have a.
do you have
yeah,
a question
the
for?
respondent, please.
Okay,
So, just for clarification, you are renting
Renting.
from them, and you're going to school
Yes.
at USF?
Oh, well, not US, Pasco and
At
Andrew.
Pasco, Pasco, okay. So you're a struggling student?
Yes,
Okay,
and I
okay.
work 2 jobs, and
Okay.
wife and 3 kids. So it's a little
Okay.
difficult. I understand I still have to stay in compliance,
Yeah.
though.
Understood. Just want to clarify, thank you.
I do have a question.
Mr. Lloyd.
If this board does assess a fine, are you anticipating paying that fine?
I would, honestly, yes, assuming it's not too much, but I would try to, just so I didn't make waves, with
Okay.
landlord.
Okay,
But yeah.
any other questions? There being none, I call for a motion. Thank you.
I'll make it. Case number 19-4158, I move that the city has proven by a greater weight of the evidence the following violations of the City of Temple Terrace Code exist on the property located at 406 Dunedin Avenue. In violation of Section 12-860 inoperative vehicles. The motion is based on the sworn testimony this board has received from the code enforcement officer, as well as other witnesses, along with any other evidence, including photos, affidavits, and a notice of violations, all of which is received and entered as part of the record of this hearing. I further move that respondent be found as a repeat violator as defined by the City Code Section 1-63, because the respondent has been found to have violated the same provision of the City Code within the previous 5 years, regardless of property address. I further move that a daily fine be assessed for the repeat violation, which would be 3 days between August 5th and August 7th. For the time of the notice of repeat violation till the time the repeat violations were corrected. Upon consideration of the following factors, the gravity of the violation, any actions taken by the violator to correct the violation, and any previous violations committed by the violator, I move that a fine of $50 per day be assessed for the 3 days for a total of $150.
I have a motion. Do I have a second? For lack of a second, the motion fails.
I thought they
Do
might
I
have
have
a
a new
problem
motion?
with the amount.
Do I have a new motion?
Maybe I can ask the city attorney, this will help clarify it for me. The original fine was $30 per day for the violation. We can go in excess of that violation because it's a repeat violation. We can go all the way up to $500 if we want, correct?
That is correct.
So it doesn't, okay. I'll make another motion.
I'm happy to amend.
Yeah, if you want to amend it, I was thinking
If the only, if the.
We haven't had a
Okay,
second.
well, if some, yeah, I'm happy to amend if the only sticking point is the dollars.
I would say, I was going to I was going to use the $30 that originally was the fine amount. So it would be $90 total.
That's fine.
That's what I was thinking.
I was looking at, should be something more than the original, but not the 250 that we could go up to.
Yeah, well, it was done within 3 days.
Yeah,
We
yeah,
got
that's fine.
people, repeat violators that,
I'll amend it to $30 a day, so $90 total.
yeah.
I'm in the second.
All right, good.
Okay, we have a motion and second on $30 per day, cap of $90. And any other discussion? There being none, all in favor?
Aye.
Opposed, nay? No nays.
Mr. Chair.
Yes.
Can I ask the renter, Mr., I forgot your name, I'm sorry. Is the $90 with a wife, 3
Oh, yeah.
kids going to school, is that within your?
I'll definitely, I'll
Okay.
pay that.
'Cause I just don't want you not to pay
More
it and then
than
be back here.
reasonable. Yeah,
Thank you.
Moving on.
Lien reduction, first one, first case.
Which one are we doing first?
The first one.
Which one's that?
Which one are we? Queenburg Court.
Oh, that's, there it is.
Ms. Shoshone.
Yes. Good evening.
Good evening.
I believe that this particular one came before you last month and was tabled so that we could find out some additional information from the title company to find out whether there was any money that was still sitting somewhere that would have paid this lien off. Deputy Clerk Garcia had contacted the title company and eventually received a response from them. I also telephoned them and spoke to them, and we got kind of conflicting information. I believe it was the email that said that, I think it was the email that said that the price of the property had been reduced at sale to reflect the lien. However, when I spoke to them on the phone, they were quite clear that they had never discovered the lien at all when doing the title search. So I don't know how they would have how the price would have been reduced or why the title company would even necessarily know that the price was reduced because of the lien. But they told me repeatedly that they had not found the lien when they did the title work. So there is no money being held anywhere to pay this lien. So that's all the information I can provide to you. So it looks like Deutsche Bank got their payment and they're gone. And so now the person who bought the property is basically on the hook for the lien here today.
Okay.
Mr. Chair, a question for Mr. the city
Mr.
attorney,
Shawn?
Michon. I don't want to mispronounce it because I know that's bad. My name gets done all the time, so. So there's no liability to Deutsche Bank or to the title company at this point because they didn't discover it? I mean, if they did title work, you would think there would be some liability for failing to do it.
The problem is, well, yes, that would be great. The case is originally against Deutsche Bank, but the lien that is placed on the property, and so now seems to become the burden of the property owner to remove the lien from her property.
Not the title company? Was there a title?
That she could possibly file a claim against the title company. There is a form for that, they said, and I did get the information that we can supply that to her so she can file a claim with them, so.
All right, thank you.
Sorry. I have a question for our attorney before he goes.
Okay.
First, the city attorney's sworn testimony is enough. We don't need emails into evidence to support this case from the respondent back from the Deutsche Bank and the title companies.
Correct, yeah.
Okay.
I mean, it's competent. You give it what weight you want to give it. It's competent substantially.
Thanks.
Director
Tom
Brown.
Baroni, Code Compliance Director. Just to refresh your memory about this case, this was a lien of $2,100. This was for overgrown conditions. This was a repeat violation case. With code staff, there was 13 inspections at this property, which, and the city clerk's cost of $550. So my first recommendation to the board was to reduce it down to $750. But based on what the city attorney said tonight, this evening, I'm willing to reduce it to $550. That would be my recommendation.
And are there any questions, Director
Just for
Brown?
clarification, are we considering this a repeat? Or,
This-
okay, doesn't matter, there's a
Right.
lien reduction here.
Right, that's correct.
No, thank you.
It's okay.
I do have another
Sure.
question for the city attorney.
Mr.
If she was to
Buckley?
appeal this with Deutsche Bank, I suppose, is who it is? You said she could appeal it, you have the documentation?
No,
With the title company?
yeah, and it's not an appeal, she would have to file a claim with them.
Do you know roughly how long that would take?
I
If we were
have
to
no
give her an
idea.
extension, or is it like a year? Or-
I have no idea what their processes and procedures are at this particular title company, but all they told me was, we have a form for that she can fill
Right.
out. Whether they honor her claim or they reject her claim,
Right.
I don't know.
And that wouldn't be particular in our purview anyway. Our decision here tonight is to grant a lien reduction or not grant a lien reduction. And if we do, then, and it's her responsibility then to appeal or not to repeal.
Correct.
Appeal.
I suggest that you make a decision here tonight as though this was a regular lien reduction, and then she has the choice to pay it, not pay it, and let it go back to what it was, or pay it and still file a claim with the title company and try to get reimbursed.
Correct. Mr. Lloyd?
Tom, what, if you can, share with us, has
Sure.
compelled you to change the recommendation from last week? And it might just be your professional opinion, I don't know.
I just feel, based on what Pam has said tonight, the city attorney has said, I just feel that, based on her testimony, I just feel I should reduce it down, lower to
Okay.
$550 than $750.
Yes.
And it is in compliance now, correct?
Yes, yeah, this is back in 2016.
Okay, yeah, just double checking.
Mr. Knapp?
Director,
Sure.
do you know if your proposed number is acceptable to the resident?
She stated that in her form, that she's willing to pay,
200. Okay.
I think it was $150?
200.
200.
The request was for 200.
200, okay.
Okay. Thank you.
Are there any other questions?
So just want to remind my colleagues here that, we're making a recommendation, it goes to council for final.
Correct.
They certainly can do what they want with it as well. And also remind them that none of these violations occurred while she was the property owner. It was all while Deutsche Bank was the property owner. So, just keep that in mind. I don't have an answer, but
Yeah.
Good evening, everyone. Good evening.
Name and address, please.
Okay, my name is Sadia Aladdin.
Can you
and
come
my-
a little closer? It's there.
Okay, my name is Sadia Aladdin, and my address is 8521 Queen Brooks Court, Temple Terrace, 33637.
So you've been through a little bit of the struggle since the last meeting?
Yeah, a lot of anxiety, but hopefully everything will be resolved today.
Okay.
Yeah.
Anything to add?
Yeah, I did ask for a lien reduction for $200, but if you all decide it's $550, then I'll just pay it because I don't want this to prolong. It's not good for my health.
Okay.
and I love where I live. I love Temple Terrace, so,
That's good.
yeah.
We do too. Are there any questions? Any other questions? There being none, thank you.
You're welcome.
And I'll call for a motion. Mr. Nopke?
In case number 160836, for property located at 8521 Queensbrook Court, Temple Terrace. Upon hearing the facts and the argument from the city and the property owner, I hereby move that the board recommend to the city council that the lien be reduced from $2,100 to $550, contingent upon the lien being paid within 30 days of the council's decision, or it would revert to the original amount of $2,100, and the city is authorized to enforce the fine in accordance with the law.
I'll second.
Motion and second by Mr. Lloyd. Any other further discussion? There being none, call for a vote. All in favor?
Aye.
Opposed? Nay?
Nay.
One nay. Mr. Buckley?
Next.
Yeah, you,
That's what we're talking about.
okay.
What's the time limit? Like 2 months, 3 months?
Once well, the councilman, I don't know which meeting it will be, but it will be,
It'll probably
could
the
still be this
October-
month, third,
October 17th meeting.
October 17th meeting. And then if they approve the 550, then you have 30 days to pay that.
And they're gonna send me a letter like when?
Yes, you will get notified.
Yep.
Should I be coming to the meeting again?
Yes, if you, yes, either way,
If you,
either way.
October 17th.
Okay, at 6:30 as well?
6 o'clock.
6 o'clock. And I will be presenting, and you can share with the council your thoughts. Okay?
I'm just glad that I have money to pay, but what about the people who don't have, like, people live on fixed income, elderly people, like this, it's like a, they may not have money to buy groceries, but they wouldn't wanna leave.
I don't think we can hear you on the tape.
Should I repeat that?
If you
Yes.
want.
I just want to say that, I'm glad that I have the ability, I'm an RN, so I have the ability to pay. But what about people who are on fixed income, like elderly people, and they don't know, or they haven't got the communication from the city hall here?
Mhm. Well, the process is long, and normally, and it starts with the violation, and the violation can be corrected by the violator. In your case, it's different, because you had nothing to do with the violation, but you've assumed because the lien goes with the property. That's the first case. They have the opportunity to correct it. They have the notification, they have the second inspection. They then, if it's still not in compliance, I don't know how many inspections you do before you bring it to us. That has to do with the code enforcement inspections. And once it comes to us, then it's a month from the time that you're notified that it's still in violation, and now it's coming before the board. There's still 30 days in there before the next meeting in normal cases. So there's a lot of opportunities to correct the situation. Once it comes to us, there's normally 30 days again to correct the situation before the fine begins. So there is,
Okay.
over 90 days just in the, if it was a single thing and everything went 30 days, 30 days.
Okay.
So,
Mind if I add something? There are mechanisms in place. I think you heard a couple of the board members say that, you have title insurance. There are certain governance that would give you recourse to possibly recoup some of those funds. So without speculating on other people's cases, that's why we hear them on a case-by-case basis.
Yeah.
There are mechanisms in place that they would be able to pursue recapturing that money, that
Okay.
they would be out. Unfortunately, it's not your fault. Somebody else had some issues there, and then, and ultimately, you do the research and you pay that title insurance, and that's what it's there for, so.
Yeah.
Mr. Chair?
Thank
If I
you.
could just add in, your situation is unique. However, I think you saw a case earlier where the board factored in the violator's ability to pay into the amount. of
Yes.
fine.
That was kind. Thank you all very much.
Thank you.
Thank you. Kristen, let's move on to the next. Okay. Tom Baroni, Code Compliance Director. At this time, I would like to introduce this lien reduction petition request in case number 14-1394, City versus U.S. Bank National Association, property located at 7911 Shore Bluff Court, with a lien amount of $15,750. This case was presented to the MCEB Board, which was found guilty of a damaged roof and a fine of $75 per day. The property was an occupied rental property, and due to the moisture entering the home, this violation became a health and safety issue. This property remained out of compliance for 3 months, with 17 inspections by code staff and city clerk costs totaling $700. There is also a $521.21 outstanding water bill. The lien amount with a lien amount as well. My recommendation to the board tonight is to lower the lien amount to $7,800, which would satisfy the code lien and the outstanding water bill. So how I came to this conclusion, okay? I took the $15,750. 10% of that would be $1,575. I added the city cost of $700, totaling $2,275. Then I also added the outstanding water lien, which is $521.21, rounding off to $2,800. Do you want me to repeat that again?
Yeah.
So I took the $15,750,
2,800, okay.
10% of that,
You said 7,800.
I'm sorry,
We all heard 70. You might have said 2,800, but we all heard 7. We all
oh,
heard
I said
70.
70, then I apologize, I'm sorry.
Okay.
It's, my recommendation tonight is $2,800.
2,800.
That's correct, sir.
Thank you.
I apologize.
No problem.
So how I came to that was the 10% of the original lien. I added the city cost because this was a health and safety issue. I was the one that presented this case to the board. There were tenants inside, there were children, and there was a hole in the peak of the roof, and it took them 3 months to fix it. So I felt it wasn't fair to the tenants paying rent. So this was a health and safety issue. And I also added the outstanding water account. Okay?
Thank you.
Sir?
You here? He was not sworn in. He did not stand.
I'd be happy to swear.
Good evening to all of the members of the
Swear
board.
him in first.
Oh, I'm sorry.
Yeah, I'll swear you in first. Do you swear or affirm that the testimony or evidence you're about to give or present is the truth, the whole truth, and nothing but the truth?
I do. Good evening to all of the members of the board, and good evening to everybody who is in attendance. My name is Manny Iravedra. I'm here in representation of U.S. Bank. U.S. Bank is the applicant associated with this lien reduction application. I've heard what the city has recommended, and I appreciate the fact that the reduction has been suggested. However, I would like to bring certain matters to your attention. Namely, U.S. Bank came into possession of this property or acquired this property in October of 2018. Now, this is years after the violations actually occurred. One big issue here is that the lien, or what the city calls a lien, appears to be not recorded. The U.S. Bank, in foreclosing on this property, the foreclosure began in 2012, filed a notice of lis pendens. That affects the ability of the city to actually enforce any lien, including unrecorded liens. The actual foreclosure sale occurred in October of 2018, but the notice of lis pendens was filed in August of 2012. All of the violations have rather occurred during that period of litigation and after the lis pendens was actually filed. As a result, what we would suggest and what we are asking for is for a reduction to $1,500. That includes the $700 towards the city's costs, and it goes above and beyond that. Our position and my client's position is that we are not legally responsible for the amount that is being required by the city as a result of the lis pendens and as a result of the lien not being recorded. And with that, I would defer to the board.
Any questions?
I didn't know, I think we all do have a few, so we'll start down there.
Okay.
I'm good.
Mr. Napke?
I was going to ask Ms. Shishon, was this lien recorded or not? Do you know? I know it's before your time, but
It was before my time, but the clerk may be able to determine whether it was recorded or not.
okay. I'd ask Kristen, was it recorded or not? And if we want to go ahead with other questions while she's doing that, that's fine, or we want to wait.
Mr. Snell?
This may be irrelevant, but just curious, when the transaction occurred, were you guys, regardless of lis pendens, were you aware of the lien?
My understanding is that, no, my client was not aware of the lien.
Okay, thanks.
Okay, point of clarification, you opened with October 2018 is when y'all took ownership of the property?
That is correct.
Okay, did you file the lis pendens in 2012, or who filed the lis pendens?
I myself did not file it. My client filed it in relation to a foreclosure action.
For the U.S. Bank?
Yes, U.S. Bank.
Okay, and then you took ownership, you took possession of the property, though, not till 2018. It took 6 years for the foreclosure process?
That
Is
is
that correct?
Yes.
Okay.
The
And do you-
foreclosure sale actually occurred in October.
And I know you're an officer of the court, but possibly there. Do we have record of that lis pendens being filed?
Yes, I do. And if I may, I would like to submit it into evidence.
Accept that.
Kristen?
It was recorded, and I have the book and page number in front of me. I believe he was just referring to the list pendants and that he's saying the bank is not legally responsible for this lien.
When was the lien recorded?
On November 5th, 2014.
So he's asking if we'll take his evidence for the lis pendens.
Are we done? Without objection, the evidence will be admitted into the record.
All
Your
right.
evidence.
And this right here would be the notice of lis pendens permission to approach.
Do you have any other?
Yes, if I may, I would also like to introduce, as evidence, the certificate of sale associated with the actual sale of the property, dated, or rather, the sale, evidencing that the sale took place on October 30th of 2018.
Okay. Without objection, the evidence will be admitted into the record.
And I'd be happy to discuss that as well. Should we discuss it now? What we'd like to do is, I can't acknowledge, I can't take the position that my client is responsible for the water bill, but if we're able to consolidate both of those issues, the lien payment and the water bill.
I still have some questions.
Yeah, I know.
Tom?
Yes.
Can I see a minute? So, you can't do that? Okay.
Yeah, okay. I got several questions. I've got several questions. I still have questions for Mr. Manny and for Tom.
We're gonna make a new recommendation.
Well,
Okay,
but
so, well, but.
Okay.
I'm sorry.
Oh, you got questions down there too?
I don't have any questions, I just, if you're ready to hear a motion, then unless they want to talk first.
But I got questions regarding, based off the other stuff and Tom's dollar amount and everything. I still have some things I need to get clarified.
Okay.
Do y'all want to go first?
Just a question. The Liz Pendants was filed based upon what was circulated in 2012. The city lien per Christian was filed in 2014, correct? Okay, I just want to make sure
Yeah.
that was correct.
I
Okay.
got no problems with that. The problems so you basically took, it's your testimony, it took 6 years to foreclose, is that correct?
To the extent that I am testifying, yes.
Yeah, okay. And you were owner of the house when it was a health safety issue in which we filed a violation? In 2014, were you the owner of the house?
No.
U.S. Bank did not own the house,
U.S. Bank did not own the house in 2014.
but you filed the Liz Pendants in 2012.
Yes. Liz Pendants is filed at when one initiates a foreclosure
Okay.
proceeding.
And are you aware of the Florida statute that allows us to go in and make those repairs and bill you for that, had that happened because it was a health safety issue?
I'm not prepared to discuss that matter, and I don't believe it's been raised.
It was filed as a health safety issue, and there's
All
a
right.
Florida statute governing that. So I just want you to keep that in mind when we make our recommendation, that you had people living in a home with small children with a hole in the roof and putting their health in jeopardy.
Well, my
After you
client
filed the
certainly
Les
didn't.
Pendants in 2012, this was 2014.
There seems to be a misunderstanding here. My client was not the owner of the property. My client did not have anybody living in the property. My client became the owner of the property in 2018.
That's great clarification. That'll help. Let me know. I think Tom wanted to come back or something.
Because of the timing of the filing of the list pendants, and we recognize that it appears that the owner of the property was whoever the owner was who got foreclosed upon was the owner of the property until the court awarded the foreclosure judgment and awarded title to the bank. Therefore, considering that the lien was filed after the notice of lis pendens and the discussion that I just had with Mr. Iravedra, we are recommending that his offer to pay, though, $1,500 be accepted, and he's also agreed to pay that his client would pay the $521 for the outstanding water bill as well. This covers the city's costs, it covers the water bill, and there's a little bit extra there as well. But I have to acknowledge that legally, once the lis pendens is filed, the filing of our lien is superfluous. I don't know what else to call it, so we're kind of caught in a strange position there that we seem to find ourselves in more and more because of these foreclosures that have taken so long and are still coming along since probably 2007, 2008. Yes.
So just for clarification, make sure my math is right. So you're talking 1,500 plus the 521 for a total of 2,021.
That is correct.
Okay.
And if I may make a request of the board, I understand that there's two components to that number. We would request that we be able to make payment in one lump sum for both those amounts.
I don't think that's a
That's
problem.
fine. All right.
We'll take
Thank
your
you.
money.
Okay, any other questions?
Can I just ask a question of the city attorney on that?
No.
I mean, the lump sum is fine, but the only thing that would go to the city council would be the lien reduction, correct? The outstanding utility bill is firm, and that won't be presented to city council, just the fine reduction amount of 1,500, correct?
That should reflect the lien, just the lien, and that would not be the water bill. The water bill is a separate outstanding bill on this property and is not part of the violation that this property was cited for that led to the 15,000 plus lien on the property.
I mean, my point being, you can probably cover them both in one check, but understand that the city council will only be dealing with the $1,500.
I understand.
Okay, but I'd like to get it on record tonight that it's, the deal that's being struck is for both.
Yeah, that's,
Yeah,
I guess the question is for our attorney, is we take into consideration several factors to determine the amount of the lien reduction. So wouldn't that be one of the factors that we would take into consideration for our recommendation to city council that we reduce it to 2021 with all the factors being outstanding bills and time and so forth?
Well, first of all, there hasn't been a motion, but from what I'm understanding being offered is that they're not reducing the code enforcement fine to 2021. They are, you're reducing recommending the reduction of the code enforcement fine to $1,500.
right.
Yeah, but I think what he's saying is that one of the considerations that we are taking into account in accepting the $1,500 offer is that the respondent is also going to pay the outstanding water bill of $521.
So that would be a negotiation to the attorney. Would he be willing to accept 2021?
I understand the two amounts equal 2021. I'm just saying you got to separate out what's a fine reduction and what's going to be the utility bill, because the utility bill aspect will not go to city council.
Well, in the past, we have included the utility bill in the lien reduction because it's part of the attachment of this document right here, that it's, in how it gets divided up to the city is not, what we're here to do is to determine what the total lien amount would be, not how it's broken down. That's up to somebody else that does finer work than us, I believe. And that's the way we've done it in the past.
I understand the practicality of what you're doing. I'm just passing to you what the legality of what you're doing is, which is the only thing you can recommend is the fine reduction. All right. That's all I'm saying. I understand what you're doing, but I just want you to understand legally, the only thing you can recommend is the fine reduction.
But when we announce this to the council, we would need to say that there is a contingent, I believe, of $512.
521.
Well, why don't we just ask Mr. Rivera if we just forget the utility bill and see if he'll agree to 2021?
That is fine, as long as that can be done. I'm just saying you got two separate
That would be,
figures from two separate, one is within your jurisdiction, the other is not.
And you've more than once stated here on the record that the reason that one of the factors for accepting the $1,500 and reducing it to $1,500 is the promise of the respondent that they are going to pay the water bill as well. So that can certainly be mentioned to council as part of your recommendation. but your jurisdiction here governs the particular lien that was imposed for the original violation, and that had nothing to do with a water bill. So,
Because if we said 2021, then he technically the water bill would still be outstanding.
Is he legally bound to pay the water bill, or what?
that would be something else I'd have to address about collecting on the water bill. But right now, you have somebody before you who is stating under oath that he's going to recommend to his client that they pay the water bill as well.
Can the water bill be included as part of the motion, but in separate the $1,500, reduced to $1,500, contingent upon the payment of the 5/21 water bill? That way you separate it out.
That type of a motion, and if you want to put that contingency in, that is fine.
Cool, I'll make a motion.
All right. That's good.
In case number 141394, for property located at, what address are we at, folks?
We are at
7911
Shore Bluff
7911 Shore Bluff
Court.
Court, Temple Terrace. Upon hearing the facts and argument from the city and the property owner, I hereby move that the board recommend to the city council that the lien be reduced from $15,750 to $1,500, contingent upon the lien being paid in 30 days after the council's decision, and that the water bill, outstanding water bill, be paid at the same time in the amount of $521, or it would revert back to the original amount of $15,750, and the city is authorized to enforce the fine in accordance with the law.
Second.
Any discussion?
Utility bill is actually what, 5/12/21?
Well, it's been stated as 521, and that's what Mr. Nappi said.
Okay.
All right.
Any discussion?
You good?
I'm good.
Okay.
Nice meeting everybody.
Thank you.
We haven't voted yet.
We haven't voted yet. Is there any further discussion?
I just want to thank Mr. Nappi for opening the sliding glass door that we kept running into.
And, Madam Attorney, is that presentable to the council from your standpoint?
I will present that to the council.
All right, thank you.
Mr. Schmidt will be presenting.
I'm going to be talking with you.
That makes sense.
Just thank you for everybody's input, appreciate that.
Okay.
Still haven't voted.
Yeah, we have a motion and second. All in favor?
Aye.
Opposed? Second was Dave.
I would just like to say that was a fine motion.
Did you second?
No
Did
pun
you?
intended.
Okay, it was David then. It was David.
Trying to get there, yes.
Okay, next,
Good job.
we've had some unusual ones tonight. A new learning game.
So we're back to 2587, is that where we're at?
Next case, please.
Case number 192587, City versus Omahan, Shahina Sadr, and Mirza Al-Zubari for the property located at 8605 Shirley Drive. The case is before the board based on alleged violation of Section 10(3)B, sanitation grass weeds. Case will be prosecuted this evening by Officer Silva. City has evidence that the notice of violation and notice of hearing were properly served.
Note to the record that the respondent is not present.
Good evening, Jose Silva, Code Compliance Officer. This case originated May 13, 2019. My inspection at the time noted the front yard grass of the residence to be overgrown. I left a door hanger with a compliance date of May 16, 2019. My inspection on May 20, 2019 found no change, so I completed a notice of violation with a compliance date of May 31, 2019. Posted notice at the front door. The residents, as well as City Hall, also mailed copies, both certified and regular mail, to the registered owner of the address of the property. I inspected the property on May 31st, 2019, and found the yard grass cut. I placed the property in compliance and closed the case. July 25th, 2019, I found the yard grass again overgrown. Since the violation reoccurred within 45 days, I set it for the MCEB hearing. At this time, I have 3 photographs I'd like to submit. Photograph number 1 is going to be the notice posted at the front door. Number 2 is going to be the overgrown yard grass on July 25th, 2019, and the overgrown yard grass on August 22nd, 2019.
Without objection, the evidence will be admitted into the record.
Thank you.
As of today's date, the property has come into compliance. Yard grass is cut, and I'm just asking for a finding. I'd like to submit affidavit of compliance.
Okay, we'll take that. Without objection, the evidence will be admitted into the record. Are there any questions for Ms. Priscilla? There being none, call for a motion.
I'll make it. In case number 19-25887, I move that the city has proven by a greater weight of the evidence the following violations of the City of Temple Terrace City Code did exist on the property located at 8605 Shirley Drive, violation of Section 10-3, subsection B, sanitation, grass, and weeds. This motion is based on the sworn testimony this board has received from the code enforcement officer, as well as, well, just the code enforcement officer, along with any other evidence, including photos, affidavits, and a notice of violation, all of which is received and entered as part of the record of this hearing. I further move that there be no fine imposed because the violations were brought into compliance prior to the date of this hearing.
Second.
Second. Which one?
Buckley or?
Buckley can have it. Both at the same time, and I wasn't looking.
Jinx by me.
We have a motion, a second. Any discussion on the motion? Vote, all in favor?
Aye.
Aye.
Opposed, nay? No nays. Next case, please.
Case number 19-3119, City versus Nafiz Ahmad and Zina Ahmad for the property located at 10029 North 52nd Street. Cases before the board based on alleged violation of Section 12861E6, fences appearance, and Section 810213B, exterior walls maintained in good repair, and Section 810213C, roofs maintained in good repair. Case will be prosecuted this evening by Officer Doug Allen. The city has evidence that the notice of hearing and notice of violation were properly served.
Note to the record, the respondent is not here, not present.
Good evening again, Mr. Chairman and board members. Doug Allen, Code Compliance Officer. This case originated proactively by me on June 7th, 2019. My inspection on that day revealed 3 violations: a wooden fence in disrepair, exterior walls not being weather tight, which led to an infestation of bees inside the exterior masonry wall, and wood trim in disrepair. I left several door hangers with a reinspection date of June 17th, 2019. Some repairs were begun, so I granted an extension to bring the site into full compliance. My reinspection on July 15th, 2019 showed no change, so a notice of violation was prepared on July 15th with a compliance date of July 30th. I posted the notice on the site, and a notice was also posted at City Hall, and copies were mailed, both certified and regular mail, to the address of the owner of record. My reinspection on August 2nd revealed that the site was not in compliance. The property's representative contacted me and asked for additional time to have the bees removed, which I granted until August 27th. A notice of hearing was prepared on August 27th as the site was not in compliance, and the case was scheduled for the September Municipal Code Board meeting. This time, I'd like to submit photographic evidence of the site taken by me on July 12th and June 29th.
Without objection, the evidence will be admitted into the record.
Thank you.
Is the property being occupied?
I do believe so. I believe there's some tenants. I believe it's a rental property. Exhibit number 1 shows the posting of the notice of violation. Exhibit number 2 shows a wood trim and disrepair. And exhibit number 3, as best you can photograph a bee, the bees on the exterior wall.
That was in picture.
I got him out of order.
It was probably number 3.
That's where the bees are?
Yeah, they were all actually in the wall itself.
Yeah, here.
I wasn't in the picture.
No, that
There's like little black dots on the wall. Those are bees.
Oh, right there?
Okay.
Okay.
You say so.
At this time, the site is in compliance, and I'd like to submit an affidavit of compliance.
Without objection, the evidence will be admitted into the record.
And I'm just requesting a finding.
Thank you. Must be.
Are there any questions? There being none, I call for a motion.
Can do.
Thank you. Mr. Lloyd?
Case number 19-3119, the city has proven by greater weight of the evidence the following violations of the city of Terrace code did exist on the property located at 10029 North 52nd Street, and code violations, section 12-861, subsection E, subsection 6, fences appearance, section 8-102, subsection 13, subsection B, exterior walls maintained in good repair, and section 8-102, subsection 13, subsection C, roofs maintained in good repair. The motion is based on the sworn testimony this board has received from the code enforcement officer, along with any other evidence, including the photos, affidavits, and the notice of violation, all of which is received and entered as part of the record for this hearing. I further move that there be no fine imposed because the violations were brought into compliance prior to the date of this hearing.
Second.
Second by Mr. David. Any discussion? There being none, call for a vote. All in favor, aye.
Aye.
Opposed, nay. No nays. Thank you. Next case, please.
Next case will be case number 194186, City versus Judith Valdez Cugat for the property located at 6109 Oak Fern Court. The case is before the board based on alleged violation of Section 8-102-13C, roofs maintained in good repair. Case will be prosecuted this evening by Director Tom Baroni. City has evidence that the notice of violation and notice of hearing were properly served.
Note to record, the respondent is not present.
Tom Baroni, Code Compliance. This case this evening originated proactively on July 27, 2019, when I observed a hole in the front of the structure roofing area. I also noted moisture on the inside of the front window. Since the home was unoccupied, I prepared a notice of violation that same day with a reinspection date of August 21, 2019. I posted a notice letter at the front door and requested copies to be sent out certified in first-class mail. I also requested a copy to be posted at City Hall for the 10-day requirement. My inspection on the 26th of August noted no change. At this time, I'd like to present photographic evidence of the violation that was taken by me on July 27, 2019. Exhibit number 1 shows a hole in the roof shingles.
Without objection, the evidence will be admitted into the record.
Thank you.
This property may sound familiar to you. It was presented last month by Officer Smith for the garage doors in overgrown conditions. I did receive a voice message 3 weeks ago about, she lives in Arizona now, and there's a financial hardship here. In her voice message, she was trying to get some money together to make the repairs. She also sent me an email today, and she said that she hired somebody, but the repairs as of today have not been taken care of, and therefore the property still remains out of compliance.
Thank you. Any other questions? Mr. Lloyd?
Is there, you said this was brought before us, is there a fine accruing on that other?
As of midnight tonight, it'll start because it was presented last month.
There being no other questions?
So
Mr. Napkin?
so we're not a repeat violation? at
No,
this
no.
point?
This is for the roof shingles.
Right.
So there'd be, if we find a violation and started finding in 30 days, there'll be 2 violations running concurrently.
That's correct.
I'll go.
Well, did she say who she hired? Or?
No, she lives in Arizona, and what I understand, I believe she put something out on Facebook yesterday. This is third-hand information. She's looking for a handyman to make the repairs. So that's about all I know.
Is it something that she'd have to get a permit to fix?
No, the hole is probably a 1x1,
Okay.
so it doesn't require a permit.
Okay.
So she hasn't hired anyone yet?
Not that I know of.
Okay.
As of today, she did send a message, an email, saying that she hired somebody, but again, the
Right.
repairs are still out of compliance.
Okay. Any other questions? Mr. Napki, we're going to go for a motion then. Thank
Okay.
you.
Thank you.
In case number 19-4186, I move that the city is proven by a greater weight of the evidence the following violations of City of Temple Terrace Code exist on the property located at 6109 Oak Fern Court. And the violations of the city code are 8-10213C. The motion is based upon the sworn testimony this board has received from the code enforcement officer, along with any other evidence, including photos, affidavits, and the notice of violation, all of which is received and entered as part of the record of this hearing. I further move that, I'm reading the wrong violation, I believe. No?
This one, existing.
Yeah. Existing, I'm sorry. Y'all should have stopped me. In case number.
You're good.
Yeah.
You can keep going.
Yeah.
You just
I
got to,
further move that the said violations be corrected on or before the October 9th, 2019. If the respondent does not comply with this order on or before this day, they are ordered to pay a fine for each and every day the violation continues past the date of the compliance. Upon considering the following factors, the gravity of the violation, the actions taken by the violator to correct the violation, and any previous violation committed by the violator, I've moved that the fine be $30 per day.
second.
Second by David. Any discussion? Call for a vote. All in favor?
Aye.
Opposed? Nay? No nays.
Next case, case number 194219, City versus Lila Naur Sahab for the property located at 1242 Pampas Place. The case is before the board based on alleged violation of section 12922A, parking commercial vehicle in residential districts. The case will be prosecuted this evening by Officer Lori Smith. The city has evidence of the notice of violation and notice of hearing were properly served.
Good evening, Mr. Chairman, board members. Lori Smith, Code Compliance. The case originated proactively on July the 27th, 2019. My inspection at this time noted a commercial trailer parked or stored in the driveway of the residence. I left a door hanger with the compliance date of July the 29th, 2019. My inspection on July the 29th, 2019 found no change. Therefore, a notice of violation was prepared with the compliance date of July the 31st, 2019. No one was at home, so I posted the notice at the front door of the residence and requested copies be mailed certified and first-class mail. I also requested a copy be posted at City Hall for the 10-day requirement. I inspected the property on August the 5th, 2019, and found the violations in compliance, and I closed the case. On August the 7th, 2019, I observed the commercial trailer parked or stored in the driveway of the residence again. Since the violation reoccurred within 45 days, I set it for the MCEB hearing. At this time, I would like to submit photographic evidence of the violations taken by Director Baroni and myself, Exhibit 1 would be the notice letter posted at the front door. Exhibit 2 is the commercial trailer parked in the driveway on August the 7th, 2019. Exhibit 3 is commercial trailer parked in the driveway on August the 15th, 2019. Exhibit 4 is the commercial trailer parked in the driveway on August the 24th, 2019.
Without objection, the evidence will be admitted into the record.
Thank you. Ooh, it's a big one.
As of today's date, the property has come into compliance, and I would like to submit an affidavit of compliance.
Without objection, the evidence will be admitted into the record.
Thank you.
I'm just looking for a finding, sir.
Thank you. Are there any questions? There being none, call for a motion.
Make this motion. In case number 19-4219, I move that the city has proven by a greater weight of the evidence the following violations of the City of Temple Terrace Code did exist on the property located at 12402 Pampas Place, violation section 12, 922 subsection A. This motion is based on the sworn testimony this board has received from the code enforcement officer, along with any other evidence, including photos, affidavits, and the notice of violation of all of which is received and entered as part of the record of this hearing. I further move that there be no fine imposed because the violations were brought into compliance prior to the date of this hearing.
Second.
Second, Mr. Nappi. Any discussion? Call for a vote. All in favor?
Aye.
Opposed? Nay? No nays. One last case.
Case number 194309, City versus Diplomat Property Manager LLC for the property located at 107 South Greenfield Avenue. Case is before the board based on alleged violation of Section 10(3)B sanitation grass weeds. Case will be prosecuted this evening by Officer Jose Silva. City has evidence that the notice of violation and notice of hearing were properly served.
Good evening, Code Board. Jose Silva, Code Compliance Officer. This case originated August 1st, 2019. My inspection revealed the yard grass of the residence to be overgrown. This time I left a door hanger with a compliance date of August 4th, 2019. My inspection on August 6, 2019 revealed no change, so I completed a notice of violation with a compliance date of August 17, 2019. No one was home, so I posted notice at the front door as well as City Hall. Also mailed copies both certified and regular mail to the address of the registered owner. My inspection on August 20th, 2019 found the yard grass still overgrown. This time I have two photographs I'd like to submit. Photo number 1 is going to be the notice posted at the front door. Photo number 2 is going to be the overgrown grass taken by me on August 20th, 2019.
Without objection, the evidence will be admitted into the record. Note to the record that the respondent is not here this evening.
Thank you.
As that photo goes around, you'll notice that buffer wall that's stained in the back of that business is not completely painted. At the time of that photograph, as of today, it's been taken care of. As of today's date, the property is in compliance. I'd like to submit an affidavit of compliance.
Without objection, the evidence will be admitted into the record.
Thank you.
I'm just asking for a finding.
Are there any questions? There being none, call for a motion.
Okay, I'll make, go ahead, hey, go ahead. Don't let me stop you.
Mr. Smith.
All right. In case number 194309, I move that the city has proven by a greater weight of evidence the following violations of the City of Temple Terrace City Code did exist on the property located at 107 South Greenfield Avenue. And the code section in violation is section 10-3, subsection B. This motion is based on the sworn testimony of this board it has received from Code Enforcement Officer Jose Silva, along with any other evidence, including photos, affidavits, and notice of violation, all of which is received and entered as part of the record of this hearing. I further move that there be no fine imposed because the violations were brought into compliance prior to the date of this hearing.
Second.
Second by Mr. Pavlovich. Any discussion? There being none, call for vote. All in favor?
Aye.
Opposed? Nay? No nays. Unfinished business.
Okay, case number 1236, City versus Judith Cugat Valdez for the property located at 6109 Oakburn Court. The deadline for compliance is tonight at midnight. Case number 3590, City versus JR Premier Properties LLC for the property located at 608 Courtney Drive. Deadline for compliance is tonight at midnight. An affidavit of compliance was submitted by Officer Silva for Section 10-3B dated August 19th, 2019.
Point of order before you move on. I don't think I heard the case number right. Would you read the case number again?
3590?
No?
We don't have that one.
No, it's 3496 is what we have on our, I'm not sure which one's right, but the one we have in our notes is 3496.
3496, it was just an error.
Okay.
We're just listening, so.
And then the last one is a repeat case number 194159. City versus Cena Realty LLC for the property located at 12909 56th Street. An affidavit of compliance was submitted by Officer Smith for Section 10-3B dated August 27th, 2019. The property was out of compliance for 32 days. And then I have one case not on the agenda. Case number 1954, City versus Safe Haven Property Investors LLC for the property located at 314 Springdale Place. An affidavit of compliance was submitted by Officer Silva for sections 810213B and 810213C dated August 20th, 2019. So that lien has stopped accruing.
Okay. New business? New business?
The election.
We have, we need to have an election tonight of a new vice chair, replacing Ryan Westwell, who resigned. And I'll take, moving right along, take nominations. Mr. Snelling.
I'd like to nominate David Begolrich for the vice chair position.
David, are you willing?
Ready, willing, and able, sir.
Second.
Okay. Are there any other nominations? Open it up.
I would nominate Sean. If he would accept.
Yeah, no, I'm going to decline that nomination.
Respectfully decline.
Yeah, respectfully decline, but thank you. I appreciate it.
We have a nomination and a second, and any discussion? I guess there being none, call for a vote. All in favor?
Aye.
Opposed?
I'm nay.
Nay? One nay?
Yes, sir.
Okay. Mr. Buckley was a nay. And that appears to be, I'll call for a motion to, Mr. Barone, do you have any comment?
I have nothing, sir.
Mr. Schoen, do you have any comment? There being none, Mr. Attorney for the board, do you have any comment? Mueller, call for a motion to adjourn.
Move to adjourn.
Second.
Second by Mr. Lloyd. All in favor? Aye. No nays. Thank you. Thank you, guys. We had an interesting evening.